just slightly ahead of time, but I'm very conscious that this is a bit kind of like the warm-up act for the thing that you've all really come for, which is celebrities having a fireside, informal, unscripted chat. So if I can just invite my panelists up for the second panel of the day. This session is on the subject of preserving wealth. Clearly, Guernsey has a long history of assisting clients to facilitate the risk management aspects associated with preserving wealth. And in that sense, I have with me Gillian Browning, Co-Deputy Director General at the GFSC. Her expertise is clearly in the role that regulation plays in managing those risks. Edward Emblem, a partner at S&W, who is an expert in the tax risks associated with that wealth preservation. Kerrie Le Tissier, the country head for Guernsey at HIGHVERN, who is the expert in relation to the fiduciary risks of those that have structures, which is clearly one of the specialties of Guernsey in particular. And Helen McGhee, partner at Joseph Hage Aaronson Bremen, LLP, who is our expert for the afternoon in relation to the legal risks, which range from divorce through all sorts of contentious disputes that are associated with owning wealth and between family members who hold wealth collectively within these sorts of structures. The topics that we'll try to cover in the next half an hour include the preservation of wealth beyond the initial earning phase from traditional investments and structuring, including in so-called passion assets such as art and automobiles, inter- and intragenerational succession planning, ensuring wealth is both protected for the future of the individual and their successors, the characteristics of Guernsey as a well-established jurisdiction with the expertise and range of service offerings to support this group of clients, and consideration of the range of products and structures available, including private trust companies, family PIFs, foundations, and in particular, I know that Gillian will focus on the Guernsey family PIF and its recent developments. And as I said, we'll talk about some of the topical subjects: passion asset investment, sustainable finance, reputation and image rights, which we were touching on in the first session as well. So one thing I should have pointed out is that the full bios of the panelists, all of the panelists today, are all on the microsite for future reference. I've just done a very quick canter through in the interest of time. If I just start with you, Edward, you've got direct experience of working with influencers as clients, as well as the old money type clients that a lot of us would be more familiar with, landed estates, etc. How do these new industry clients evolve as their careers progress, and how different is working with them later in their careers compared with when they started?
Thank you. Can you hear me okay? Yeah. No, great question. I think if the question is, do young wealth creators ever slow down and settle down? I think, no, that doesn't happen. They're just like any group of entrepreneurs, they keep going. And so the social media influencers that we work with, they might have tapped into the idea of using their personality as an asset, but that's just a manifestation, I think, of a drive to create, to see an idea through. And they might be doing YouTube videos one day, but then they move on very quickly to whether it's reality TV or whether it's launching a book or launching a podcast or a health business or a fitness business. And I think that it's the job of the advisor to keep up in those early years and make sure that if you're in between phone calls 2 weeks apart, that you're not in a situation where the client's going to put a load of things together in that space of time that you then have to either work with knowing that they're not quite right or have the awkward conversation with the client. And so I suppose it's the evolution is then in that maturity of mindset of approaching the advisor, making sure that they're comfortable with the advice that you give, so that if you do have to break sort of slightly awkward news to them, so for example, all of those gifts and hospitality that you've been getting in exchange for your services that you think are freebies, and actually in some cases they might be subject to tax, that they're not going to ignore you or take some advice that they think suits them better. And And even incidentally, if they do like it, I had a situation where my tax advice was the subject of a YouTube video because the influencer had got it but wanted to share that message. Don't look it up. But whilst they themselves was quite happy with it, the comments, some of them had a slightly different view. So yeah, at least I didn't get cancelled. But yeah, going back to the point, I think it's that as they evolve in their journey, taking on board that advice, especially if there's someone who has been used to working a lot of things out for themselves and making sure that you're the sounding board for that advice.
Brilliant. Kerrie, where Edward has given the sage advice and it's been taken on board by clients like this, the challenge for a fiduciary in trying to get the point across about preserving wealth for them and their successors, how do you find that?
Well, I always start from the same position, sort of making sure we really get to know the client and not assuming that all clients, all wealth creators, or all entrepreneurs are the same, because obviously they're not. The session before touched on this and looking at their objectives and each individual's objectives and what they're trying to preserve for starters. So what their assets are, what the wealth creation process has been, and whether or not the wealth creation is through intellectual property rights, or if there is a business that's already in a company, and how complex that already is. Because when the client comes to a fiduciary, they're already fairly far into that journey. So we're getting to know the individual, what their objectives are, what their focus is, and when they're looking at planning for the future, exactly what that is. So who they're preserving the wealth for. If we're talking younger wealth creators and entrepreneurs, they might not really be thinking about family or children yet, which is quite different to the typical clients we've historically dealt with in Guernsey. They tend to be sort of entrepreneurial families, multi-generational families, and we are thinking about sort of children, but younger wealth creators might not got that far yet, but they might be looking at business continuity and ensuring the business isn't broken up and sort of held within one kind of consolidated entity or structure. Asset protection might mean something different to an entrepreneur or a younger wealth creator in a different industry. So asset protection, obviously we're talking about protecting the wealth from external threats, but what are those external threats that they're dealing with? If their business is through making a product, say, that there may be real threats of litigation, threats to reputation. The threats might not be sort of what we've typically looked at when we're dealing with kind of cross-border families, say. They might be quite specific. So we get to know those objectives, get to know the clients before we even think about a structure. And then we can start talking about, well, is a corporate entity appropriate or a trust? And trusts have been our bread and butter in Guernsey for a long time, and we've got a lot of experience with trusts, but more and more we're dealing with other types of structures. So companies, protected sale companies, we come across those sometimes in private wealth structures. And now the family private investment fund is another solution. So we've got all these different structures we can look at, but we don't get to that until we've understood exactly what the objectives are. And
build that relationship of trust and confidence. Because obviously when we are talking about innovative products like the family investment vehicle, Gillian, do you want to just talk to us a little bit about that? Because obviously clearly when things are new and different, everybody kind of needs to get their head around it and make sure that they understand it well enough to be able to talk to potential clients about how to use it.
Yeah, thank you. So just building a little bit on what Kerrie was already saying, just taking a step back, I mean, Guernsey was one of the first jurisdictions in the world to ever regulate fiduciaries, and currently we have 125 private trust companies in the jurisdiction and 144 full fiduciary licensees, and they manage many, many hundreds of billions of assets in liquid assets. It might be company shares, it might be real estate, it might be patent assets, and investors come from around the world, but particularly US, UK, EU, and the Middle East. And what we've observed as a regulator is a maturing of the fiduciary market in Guernsey. We've had almost 30 years in this space. And as part of that maturing, we've seen a move towards an interest in more investment type vehicles. So today what we've been announcing is the opening up of the family PIF to fiduciaries to make it easier for family PIFs to be offered. So I think these are a complementary product alongside trusts. They still very much are the bread and butter of the jurisdiction. I guess what we see is that they can be, perhaps in some cases, more tailored to the circumstances of the ultra-high net worth individual. They have the benefits of the collective investment schemes. They're regulated by us, but their regulatory approval can be achieved through as little as 24 hours through our online portal. And what we try to do as a regulator is calibrate the regulatory framework to the investors' needs and requirements, and this is one way of doing it. In terms of when we say we're opening up, making it easier, we're reducing some of the regulatory fees associated and modifying some of the regulatory requirements because we're very conscious of the target market for the family PIF.
Thank you, Gillian. Helen, in terms of this question of trust and confidence that's required to get to know and understand these clients, I know you were saying earlier that you've started with some clients who were in contentious situations and having migrated through that contentiousness, continue to work with you because they have that level of trust and confidence. How important do you see that combination, that relationship being in terms of preserving wealth?
Super important, I think. And I guess what where you're getting at is gonna what we've seen this morning. There's some recurring themes throughout what everyone on this stage is saying. We're talking a lot about education, and Alice and Tom talked this morning about education from a financial perspective. I think what we're sort of now talking about is education from the legal fiduciary perspective. And we've talked a lot about relationship building, and we've talked a lot about comms, and all of that it sort of gets rolled into one. And just pausing for a second there on education from a legal perspective and education, the next generation of wealth, the onus is on the advisors to educate because they're the ones who know the investments, they know the structures inside out. So they've got to find and take the opportunities to educate, explain. I said, Alice and Tom talked about the financial side, but in terms of the legal side, not everyone knows what a discretionary trust is. Especially some of the people coming into this wealth structure. What is a discretionary trust entitlement? What does that look like? You're entitled to ask for a distribution, but to be clear, that money is not yours. And understanding what's a protector there for. That the protector's there basically to uphold and guard the settler's intentions and to look at the management of the trust. These kind of concepts that we and a lot of us in this room live and breathe and see where things go wrong. If you get in at the beginning, and we'll touch upon this as we just talk about this more, it's about sort of making sure everyone understands that there's that transparency around who's doing what and what are the rules around this. Is there an open distribution policy? Have people been talked through what the distribution policy looks like? What is it? What are the investors? And I think, again, the panel earlier were talking about this increased curiosity that's coming from the younger generations. They want to understand what an investment policy is so that they can understand how this wealth is going to grow and therefore how they kind of guard it. And the advisors are there to keep track of this kind of evolving policy within the family, philanthropic needs, desires, and to nurturing that relationship with the advisors means that that's how you help grow it. And it is all about understanding the importance of good relationships with the advisors, understanding the enormity of the power of some of the guardians, and some of that is people that have been put in place via a trust corp or whatever, but it's about respecting what these people are there for. And I can see some people in this room have been through some of these battles with me, that many a time we come across where a beneficiary takes a trustee to court because they disagree with the distribution policy that's being followed. Very few judges will want to upset that relationship, especially if because the reason why this case is coming before them is because somebody didn't take somebody through and nobody understood from the beginning. There's very little judicial sympathy there. They will uphold a decision of a trustee.
Yeah, I think you make an excellent point in emphasising the importance of transparency. I think it's, in recognising the history of this industry generally, I think it's fair to say that opacity was a characteristic 10, 20, 30 years ago, and that what we need to recognise is that time has moved on. And that isn't just in terms of the new structures, that is in terms of the old structures as well, and that actually the need to use the strength of those relationships to help people to move to contemporary standards is not something that I think everybody is kind of as cognizant of as perhaps they could be. I think the tide has gone out on some of our structures generally. I think Guernsey perhaps as a jurisdiction isn't necessarily a huge problem for us, but I think there are issues in the industry generally around all of that. Edward, moving on then to the passion assets characteristic, there's obviously an appeal for younger wealth owners to own art, watches, although perhaps not in London, and automobiles, the sorts of things that can be presented on social media. How do you kind of, as an advisor, make sure that this lifestyle inflation doesn't jeopardize the long-term prosperity of them and their successors, and it's kept in balance?
Sure, yeah. Well, I think there's a bit of a myth that young wealth creators are all into passion assets. I think some of them now, especially over the last couple of years, feel that it's maybe a bit ostentatious or tacky to be flashing your wealth. But certainly that conspicuous consumption, which leads to that lifestyle, lifestyle, what do you say?
Lifestyle,
inflation, lifestyle inflation.
Inflation.
Yeah. So that lifestyle inflation that sort of risks not overtaking their actual earning capacity, whether that's lottery winners or anyone who comes into wealth, there's always a risk there. And in fact, I had a client who was 23 years old, had come into £75 million very suddenly and bought a helicopter on impulse, admitted that she'd done it just to impress her sister. And I think, it's being able to have those conversations where you say, while you're thinking in your mind, fantastic, you've bought this ridiculously expensive, fast depreciating, highly liquid asset. That's great, but let's help work out the logistics and the practicalities and make it work for you. And I suppose, again, coming back to that point of being that sounding board, which means that when they come to you with those sorts of questions, you can then start having the bigger conversations about, for example, that's great, but how about that philanthropic venture that we talked about? Or how about a plan for the kids when they come along? And so, again, being front of mind, making sure the client's coming to you and that you're able to give them a steer in the right direction.
Absolutely. Kerrie, when wealth opens up and these doors are opened into investing into their passions, what are the considerations that advisors need to discuss with them, and how can they be structured in such a way that they protect and preserve to the greatest degree possible?
So I think the important thing is to start with the purpose and motivation behind buying an asset like that. Is it that they genuinely enjoy cars or helicopters, planes, boats, luxury property, so on? Is it a genuine personal enjoyment? Do they intend to use it? Have they bought it as a status symbol to impress their sister or others? Or is it an actual well thought through investment strategy? Have they done the research? Are they actually thinking about it from a kind of diversification perspective as a long-term investment? So that's where the conversation would start. then I'd be looking at whether or not it is a one-off investment or if it's the beginning of a collection, say, of cars or artwork, because that would help shape what a structure around it might look like. Then there's some initial legal and tax considerations or bits of information that we'd need to know so that we can work out the legal and tax side and take appropriate tax and legal advice. Things like where the assets are actually located, who would be using them,
where they're being used, how they're owned, if they're an asset that is registered on a registry, so like an aircraft property, or if it's sort of more complex than that. And all the while would be sort of making sure we're teeing up advisors, because all these assets have all got their own kind of characteristics, complex issues that will need resolving, and that's before we get on to looking at a structure. But then once we've got all that information and the advice on how they're owned, tax considerations, then we can look at different structures. And again, Guernsey's got a full range of structures that we could use. One of the most common structure for owning these types of assets is simply a company, a special purpose vehicle, either as a standalone entity that will just hold the asset, and if it's intended to be one investment, a one-off, like a car or a plane, that might be a straightforward way to hold it. And having an asset like that in a company can help with things like licenses. If the intention is the property, the asset will be used by others, like a yacht. Quite often we'll find that whilst the yacht has been bought because the client's going to have personal enjoyment, they're probably not going to use it all the time or that regularly. So sometimes they do look at chartering it out, and using a company is kind of quite a straightforward way of doing that. But then we need to look at the ownership above the company, and that's where things like structures like trusts are really useful for the ownership and succession planning. But then there's other structures as well, like foundations, which I didn't mention before. Guernsey has foundations which are very familiar in civil law jurisdictions, but we've got our own foundation, and but they're often used as asset holding vehicles. You set up a foundation for a particular purpose, and that could be holding specific assets for specific reasons. So they could be really well suited to passion assets. Trusts as well, and a specific type of trust that we see a lot of is a non-charitable purpose trust, and they're particularly useful for holding assets as well that may be held for a particular reason. So to hold property for a particular use, to hold a collection of artwork to be displayed in a particular gallery and so on. Yeah, again, there's lots of structuring options, but it's getting the advice right at the front, and tax is usually a big consideration, particularly around these types of assets, because that they could be located in so many different jurisdictions, held in different ways, and it is quite complex. So as a trustee, my first port of call would be, what do the advisors say, what do the tax and legal advisors say before we set up a structure around this?
That's excellent. And I guess, the complexity of this area does mean that where it all goes horribly wrong, the costs can be very significant, whether they're through divorce or commercial disputes or other forms of contentiousness. Helen, how important do you think the issue of education is in relation to those early initial earning phases where people, as we said in the earlier panel, they are very kind of special purpose vehicles in their own right. They're very focused on making money and doing the thing that they know really well. Do you think as a community of advisors we get involved early enough in having these sorts of conversations?
Well, it's a good question, and I think you're coming at it from, because I'm a disputes lawyer, like we see it all at the back end and it's all gone wrong. When we're looking at where it's all gone wrong, the wish is always, oh God, I wish we'd have got in earlier so that this hasn't gone so horribly wrong, and so that you don't see this huge dissipation of assets because it's being spent on legal fees or whatever else, because the dispute needs managing and stuff. So on top of have the right people in place, make sure, what I was saying earlier, make sure everyone understands what's what, is actually my main piece of advice is make hay while the sun shines. So while everything's good, make sure everything is in place for when it all goes bad. And that's relatively easy to do from an advisor's perspective. It's very difficult to do from the individual's perspective, because most of the time the things that drive dispute are life events, are divorce and death. And, nobody knows when those two things are going to happen, but we as advisors are very battle wary. We can anticipate all these things, get a good prenup in place, get a well-drafted trust deed in place. The trust deeds, there's no reason why trust deed disputes clause can't be much more akin to a commercial contracts clause that, that sets out very clearly what happens in the event of a dispute. It can be a tiered or a staged process in terms of dispute resolution, mediation, time-like constraints, when decisions have to be made by in the event of a dispute, where choice of jurisdiction. We're here in this lovely venue today talking about Guernsey, because Guernsey is a very popular choice of jurisdiction. In Guernsey there's a strong bench, supportive judiciary, reliable, enforceable judgments, speedy judgments, all that kind of thing can be folded into any agreement, and therefore, in the event that something goes wrong, people understand the process as to how a dispute can be resolved. And so, again, I can see people who, again, have lived and breathed some of these same disputes with me, that where you see things go so horribly wrong is where the individuals maybe attempt to resolve it themselves, and yet 2 years down the line, absolutely no progress has been made. They've pulled in lawyers ad hoc, they've done random things, but know when to ask for help, and know that the threat of judicial intervention, judicial oversight can be a bit daunting, but you will get results from it.
Gillian, on that point, obviously clients have a huge range of choice in terms of their jurisdictions that are available to work with. In terms of you as a regulator, how do you make the environment accessible to all different types of businesses to ensure that clients have the range of choices as advisors that they would want to work with?
Yeah, so Guernsey is home to all sorts of different types of diverse businesses, from the small boutique to the very large international group, and we regulate them all, and we do on-site visits and collect data, everything you'd expect a regulator to do. I guess what we do in particular to focus on that enabling environment partly is getting out, not just being in the regulator's glass box, but, speaking to businesses, but also speaking to prospective clients, speaking to introducing lawyers off island to see what's happening, what are the themes and trends. We also have invested quite a lot in technology ourselves to make us as efficient as possible. So we have our authorizations and application portal where, if you wish, you can track your application like a DHL parcel. So it doesn't just go into a regulatory grey box and you wonder what on earth has happened, but you can see what's been progressing.
Brilliant, thank you very much. I'm conscious that we're pretty much on time, so if we could do the same as I did with the previous panel, just ask each of you for a couple of final thoughts to wrap up the session ahead of our fireside chat. Who'd like to go first?
Just something on the flexibility of structuring. I think that there's often a case, and we've seen this in the previous session, that on the one end of the scale, you've got maybe the solution which is most flexible but isn't particularly tax efficient. On the other end of the scale, you've got something which might be really tax efficient but doesn't actually offer all that much flexibility. And often it's a case in conversations with clients of finding the right place on the scale. And also we heard about the psychology of investing. I think the same is true of structuring and tax advice, that they say that it's the path of least regret a lot of the time, that people regret things that they haven't done more than the things they have done. So sometimes testing with a client how a scenario might look from a certain future perspective can help them work out whether they're in the right place in the decision-making process at the time.
Very sage advice. Kerrie?
I would say big takeaway here is that it's not a case of one size fits all when we're looking at structuring for private clients who have accumulated private wealth. That historically, like I said before, we have a lot of trusts in Guernsey. We've set up them for years, and the discretionary trust is very familiar to all of us. But more and more, we're seeing different types of structures and recognising that our clients are changing. They're more and more diverse. The wealth is coming from different places and in different ways. So we need to evolve and be ready to use our structures differently and to use the full range of structures available to us, and just sort of always keep that in mind that, one size doesn't always fit all.
Definitely. Gillian?
Yeah, just building on that, my takeaway is probably similar to Kerrie's in that there's a range of different structuring options in Guernsey. I think everything we've talked about today you can do. If there's anything particularly innovative and you're thinking, oh, this might be a new way of achieving an even better outcome for your clients, then come and do talk to either lawyers or advisors on the island or us as a regulator. We're very happy to sandbox and just try things out with sort of regulatory support if something's particularly innovative. So I guess it's that we're open for business and you can do it all.
Thank you very much. Helen, final thoughts?
Shall I finish on a Ted Lasso quote? Be curious, not judgmental. Come at this, have no preconceived ideas, and everyone come at it with an open mind and education, relationships, communication.
Brilliant. Thank you very much indeed to all of you. If I could ask you all to join me in thanking our panellists.